The Pennsylvania Mock Trial Competition is being brought to you by the Pennsylvania Bar Association, which strives to promote justice, professional excellence, and respect for the law, improve public understanding of the legal system, and provide access to legal services for all citizens. And by the Pennsylvania Bar Foundation, representing the commitment of Pennsylvania lawyers to promote youth justice education and to ensure equal access to the law for Pennsylvania's most vulnerable.
Alzheimer's disease may have taken away my dad's independence, but a lawyer is protecting his rights. We didn't want Dad to live alone. A lawyer assured us he wouldn't have to. And when Medicare wouldn't cover his medical expenses, a lawyer made sure it did. When Dad's finances were a mess, a lawyer organized them. Alzheimer's disease may have taken away my dad's independence, but a lawyer is protecting his rights.
Skeptics said I would never start my own company. A lawyer said I would. I was denied my loan, but a lawyer helped me get one. I couldn't get a lease for my business, but a lawyer saw to it that I did. Skeptics said I would never start my own company. A lawyer helped me prove them wrong.
You may be seated. Ready? Yeah. Do you want to give them the certificates and stuff now? Well, you're going to hang out in the back, so you'll be here when we time. Before we begin, I'd like to once again welcome all of you to the Pennsylvania Bar Association Young Lawyer Division High School Mock Trial Finals. This is our 35th year. We're proud that these two teams have made it to our final round. We'd like to take this opportunity just briefly to thank the Pennsylvania Bar Foundation for their financial support of this program, specifically which includes the filming of today's trial, as well as the Dauphin County Court Reporter's Office, which will be transcribing the trial today, so that each team will receive, or each student will receive a memento, the transcript of the actual trial today. I'm going to turn it over to my colleagues and friends, John Grode and Jen Menekeny, for some further announcements.
On behalf of the writing committee, it's my privilege to read the case summary for today's trial. Tiger Mix, it's great. Or so that's what they say at Tigertail Technologies, also known as TTT, a corporation operating its burgeoning enterprise in Pennsylvania. Tiger Mix is a cutting-edge, cost-effective packaging product made from 100% organic material that has been taking the country by storm. TTT was a perfect place for bright upshot Silva Morel, an immigrant from Xanadu, one of Europe's smallest nations. In the summer of 2014, Silva landed a highly coveted paid internship with TTT. Silva seemed poised to earn a future spot in a fast-track leadership program that carried visa sponsorship through TTT after Silva graduated from Calmia University. During the summer internship, Silva was invited on a business trip to negotiate the distribution of Tiger Mix through Xanadu. The trip was hugely important to TTT. If obtained approval for the sale of Tiger Mix there, the whole European market would open up and earn TTT millions in profit. While in Xanadu, Silva claimed to have observed a TTT representative attempt to bribe a Xanaduan government official in exchange for helping Tiger Mix through the licensing process. Shortly after this meeting, Xanadu approved the sale of Tiger Mix. Upon return to America, Silva reported the alleged bribe to TTT officials and later to an SEC investigator. TTT later settled with the SEC and paid a fine after admitting to accounting irregularities, but not bribery. Silva claims that this whistleblowing led to a series of retaliatory conduct by TTT, ultimately resulting in TTT refusing to hire Silva into the leadership program and sponsoring the visa. TTT denies any retaliation against Silva and claims its decision to not hire Silva was based upon genuine business-related factors, including that Silva was a mediocre intern and a loose cannon prankster whose final prank posted on YouTube may have exposed TTT's business secrets. Trial is joined, and a jury must decide, was rescinding Silva's employment offer retaliation against a whistleblower to cover up a bribe, or a business decision to cut ties with an unreliable employee?
Thank you. My name is Jennifer Menekeny, and I am also pleased to be here on behalf of the Mock Trial Executive Committee. We are honored to have the Honorable James J. Ross presiding over the trial today. Judge Ross is a judge in the Court of Common Pleas of Beaver County. Prior to taking the bench, Judge Ross was in private practice for many years. He's also the current chair of the House of Delegates of the Pennsylvania Bar Association. He's a longtime and dedicated supporter of the mock trial program, and we are honored to have him presiding today.
All rise. Court is now in session. The Honorable James J. Ross presiding. Please be seated, everyone. Good morning. At this time, the court calls the case of Silva Morel versus Tigertail Technologies, Incorporated. There are a few things I'd like to go over before we begin the trial. And first, I'd like to welcome everybody here on behalf of the court as well as the Pennsylvania Bar Association. I hope you will all keep in mind one thing. Although it's fun to win, there are really no losers in this competition because it is important in your growth and development. I think this is one of the crown jewels of the Pennsylvania Bar Association, and I've personally been involved in this now for 27 years, and I've thoroughly enjoyed every minute that I've spent involved in this program. Above all else today, all of you young people out there, have fun because this is important. Remember, no communication is permitted between competing team members and any other individuals in the courtroom. The timekeepers, just so I know where they're located, right here to my left. All right. Have you exchanged your rosters?
Yes, Your Honor. Yes, Your Honor.
If you've already been told this, but I'm just going to remind you, please turn off all portable devices. Do not take any phone calls in the courtroom. If you need to step out for that purpose, please do. What I would like everyone to do at this time from each team, starting with the plaintiff, is to introduce yourselves and the role that you will play.
Yes, Your Honor. My name is Eden Elma, and I will be directing Silva, crossing Casey Porcini, and performing the closing statement.
Good afternoon, Your Honor. My name is Kate Plechko. Today I'll be directing Madison Blewett and crossing Patty Straw.
Good afternoon, Your Honor. My name is Emma Bender, and today I'll be directing Harley Agarikis, crossing Riley Inoki, and giving the opening statement.
And these are our witnesses.
Hello, I'm Jeffrey Backus, and I will be playing Silva Morel.
Good morning, my name is Maddie Hadberger, and I will be portraying Madison Blewett.
Hello, my name is Colt Casey, and I will be playing Harley Agarikis.
Thank you. You may be seated, and if the defense will do the same at this time, I'd appreciate it.
Yes, Your Honor. Good afternoon. Good afternoon, members of the jury. My name is Meghna Melkote, and I'll be performing the direct examination of Riley Inoki, the cross-examination of Silva Morel, as well as the closing argument. I'm joined by my co-counsel.
Good afternoon, Your Honor, members of the jury. My name is Corey Bone. I will be performing the direct examination of Casey Porcini and the cross-examination of Madison Blewett.
Good afternoon, Your Honor, members of the jury. My name is Shaylee Desai, and I will be performing the opening statement, the direct examination of Patty Straw, and the cross-examination of Harley Agarikis.
And, Your Honor, our witnesses.
Good afternoon, Your Honor, members of the jury. My name is Molly Leahy, and I am Casey Porcini. Good afternoon, Your Honor, members of the jury. My name is Delane Gums, and I am Patty Straw.
Good afternoon, Your Honor, members of the jury. My name is Phil Boulette, and I am Riley Inoki.
And, Your Honor, we're joined by our lovely timekeeper.
Good afternoon, Your Honor, members of the jury. My name is Morgan Price, and I am the timekeeper for the defense.
Thank you all. Are there any pretrial matters that you would like to address with the court at this time?
No, Your Honor, the plaintiff has no pretrial matters.
Your Honor, the defense has a few.
You may.
First, we'd ask Your Honor's preferences in moving about the courtroom, approaching witnesses, and approaching opposing counsel.
Feel free. This is your trial.
Yes, Your Honor.
Okay.
And we've also got copies of the relevant legal documents, the rules of competition, the supplement to today's case, and the rules of evidence. And may we tender to the bench?
You may. I have a copy, but I'll take what you have there.
May I first bench?
Thank you. Anything else in pretrial?
Yes, Your Honor. We'd like to draw the court's attention to Rule 4.7. It states that all witnesses have been constructively sequestered, barring our party representatives. And our party representative is Mr. Riley Inoki.
Okay.
And, Your Honor, we'd also like to draw the court's attention to Rule 6.17. It states that all objection arguments will be held constructively outside the jury.
Thank you.
And with that, Your Honor, the defense is ready.
Okay. Are both sides ready for trial?
Yes, Your Honor.
Yes, Your Honor.
Would the witnesses please stand at this time? Raise your right hand. Do each of you solemnly swear that you will testify truthfully and in accordance with the rules of the mock trial competition, so help you God?
I do.
Okay, the witnesses having been sworn, we're ready to begin with trial. At this time, I will recognize plaintiff's counsel to make an opening statement.
Yes, Your Honor. May it please the court. Bad things happen to good people. And as a result, a hardworking, dedicated, and honest employee has lost years' worth of work and has been forced to abandon his dream, all because he did the right thing. The only reason that Silva Morel was not hired was because he reported a bribe. Good afternoon, Your Honor, members of the jury, and opposing counsel. I, along with my co-counsel, am here to represent the plaintiff, Silva Morel. Today we must prove to you by a preponderance of the evidence, which means that it is more likely than not that Tigertail Technologies withdrew their offer to hire Silva Morel as a result of his whistleblowing activities. Our story begins in 2014, when Silva was given the opportunity of a lifetime in America. He had previously lived in the small country of Xanadu until he fell in love with the idea of the American dream. Silva excelled at Columbia University, which led to him being accepted into an internship program with the Tigertail Technologies company. This opportunity was extremely vital to Silva because his visa conditions stated that in order to remain in the United States, he needed permanent employment. At first, the company was a dream come true for Silva. Casey Porcini, Tigertail's business development manager, personally recommended Silva into the company's leadership development program. Silva was thrilled when the company's CEO informed him that he had been accepted. In July of 2014, Silva was invited to accompany Casey and several other Tigertail executives on a trade mission to Xanadu in the hopes of expanding the company product to Europe. While there, Casey was so impressed with Silva that she assured him that his stellar work performance would guarantee him a permanent spot in the company. Up until this point, the trip had been a huge success for Silva. However, everything changed the following day, when Silva saw Casey propose a bribe of $5 million to an official of Xanadu on behalf of Tigertail in exchange for allowing the company product into the European market. Then Casey threatened Silva, warning him not to say anything about what he had seen, leaving Silva to fear for his job and his future in America. Upon his return from Xanadu, Silva was praised for his work performance on the trip and the success that he had had. However, because he knew it was the right thing to do, Silva informed Riley Inoki, the company lawyer, of the illegal actions that he had witnessed in Xanadu. But when Riley failed to properly investigate this bribe, Silva took the information to the Securities and Exchange Commission and reported the bribe there. As you will see today, despite Silva's impeccable success in Xanadu, it was only after he reported the bribe that the company began treating him unfairly. Despite the decision to not hire Silva being made at the end of his internship, Tigertail decided to wait nearly a year to inform Silva that he would not be hired. intentionally leaving him no time to find another job. As a result, Silva has been deported from America and forced to return to Xanadu to work in furniture sales. And this is all because he reported a bribe. Therefore, Silva has decided to sue Tigertail Technologies in an attempt to gain back some of what the company's corrupt actions have stolen from him. The plaintiff holds the burden of proof in tonight's case. We must prove to you that it is more likely than not that Silva was protected in reporting the bribe, that he suffered an adverse employment action, and that the reason that the company rescinded his offer was because he reported the bribe. This burden will be met today through 3 witnesses. Silva Morel will tell you a first-hand account of the events that occurred, along with how his actions were reasonable, necessary, and should have been protected. Madison Blewett, the Director of Human Relations at Tigertail, will testify to Silva's impressive work ethic within the workplace. And finally, Harley Agarikis, an expert in forensic accounting, will state the facts on the bribe that occurred, along with the company's refusal to properly investigate this bribe. Members of the jury, by the end of today's trial, you will see that Silva's offer to join the company was rescinded, not because of poor behavior in the workplace, but rather because he reported Tigertail's bribe. You will see that Silva lost everything, all because he did the right thing in following the law. Bad things happen to good people. But you have the opportunity to change this today and give Silva back what was so wrongly stolen from him. That is why, at the end of today's trial, my co-counsel Eden Elma will respectfully ask that you find Tigertail Technologies liable. Thank you.
Thank you, counsel. Is the defense ready to give its opening statement?
Yes, Your Honor.
You may.
May I proceed, Your Honor?
You may.
Actions speak louder than words. What we do is more significant than what we say. Now, I expect Mr. Morel to come before you today and tell you that he was fired because of what he said, because he told the truth. But the evidence will show just the opposite, that his offer was rescinded because of what he did. May it please the court, opposing counsel, members of the jury. Tigertail Technologies was a brand new company whose creation was a packing product called Tiger Mix. They had an internship program, and they were hoping one intern would be offered a job into their leadership development program. But today, you're going to hear the story of 2 interns, Patty Straw and Silva Morel. Now, Patty Straw worked hard, but Silva Morel was a prankster. You'll learn that when Mr. Morel was just an intern, executives were willing to look the other way. But then, both Mr. Morel and Ms. Straw were offered positions into the LDP. And with this offer came heightened expectations. Patty Straw met those expectations, but Mr. Morel didn't. And TTT was left with no choice but to rescind his offer and give the job to Patty Straw. Now, in today's case, we, the defense, represent Tigertail Technologies. Plaintiff bears the burden of proof. They must prove by preponderance of the evidence, being more likely than not, that Mr. Morel engaged in protected activity and suffered an adverse employment action because of it. The burden then shifts to the defense. We must prove that Mr. Morel's offer was rescinded for a legitimate, non-retaliatory business reason. Not only do we accept this burden, but members of the jury, we embrace it. We'll show that Mr. Morel was unprofessional, dishonest, and irresponsible. First, Mr. Morel was unprofessional. Now, Attorney Bender told you that on a business trip to Xanadu, Mr. Morel had impeccable success. But Patty Straw and Casey Porcini will tell you that on the most important meeting in the history of TTT, the plaintiff got drunk, nearly costing the entire trade deal. You'll learn that he spilled his drink on a foreign official and he insulted other delegates. The plaintiff himself will tell you that he was so drunk he can't remember anything from that night. Second, Mr. Morrell was dishonest. You'll learn that after getting drunk, more executives became concerned with his behavior. So they held a staff meeting. You'll hear that at this meeting, management was informed that Silva Morrell, their prospective executive, plagiarized people's work. Third, Mr. Morrell was irresponsible. The plaintiff himself will tell you that he broke into an executive's office and filmed a prank video. Mr. Riley Inoki will tell you that in this prank video, which was watched by 85,000 people, were TTT's top trade secrets. Secrets that could destroy the company if exposed. You'll learn that when the plaintiff was ordered to take the video down, he refused. Not only was he irresponsible, but he was insubordinate. Members of the jury, in business, we are judged by our actions, by how we perform. Silva Morrell dreamed of being an executive, but his actions showed that he wasn't ready. He got drunk at a business meeting, plagiarized people's work, and posted trade secrets online. Throughout the course of today's trial, the evidence will show that Mr. Morrell's offer wasn't rescinded because he blew the whistle. It was rescinded because he was a liability. That is why, at the conclusion of today's trial, my co-counsel, Megna Melcote, will ask you to find today's case in the favor of the defense and TTT not liable. Thank you.
Thank you, counsel. Is the plaintiff ready to call his first witness?
Yes, Your Honor. The plaintiff calls Silva Morrell to the stand.
You may proceed whenever ready.
Good afternoon. Could you please introduce yourself to the jury?
Good afternoon. My name is Silva Morrell.
Could you tell us a little bit about your background?
I was born in a small northern European country called Xanadu. Growing up, I always wanted to get out of my country and chase the American dream, so I entered into an engineering contest that my country holds annually, and after winning this contest, I was admitted into Calmia University in Pennsylvania.
What were your goals once you arrived in America?
My goals once I got to America were to finish my education through Calmia and then find a place that would sponsor my work visa so that I could stay in America.
Why were you interested in working for Tigertail Technologies?
So Tigertail makes this really cool product called Tiger Mix. It's a versatile packaging product made from mushrooms, and I personally really saw a lot of potential in the product and the company itself.
What was your experience like working at Tigertail?
I absolutely loved working for Tigertail at first. I would come in early and stay late, and along the way I got to meet some interesting personalities at Tigertail, including Casey Porcini, who was the business development manager.
What was your relationship like with Miss Porcini?
Over time, Casey and I became pretty good friends. Casey even helped me get into the company's leadership development program.
Now, you mentioned the leadership development program. Could you explain what this was?
Sure. The leadership development program is Tigertail's program for training people they believe would make excellent managers in the future.
Were you admitted into this program?
Yes, I was admitted. I received an email from the company's CEO, Mr. Canopio, informing me that I would be on their official list in spring.
What happened after you received this email?
After I received the email, I was absolutely elated. I never really thought that I could get into this program. So I emailed Casey and immediately thanked her for all she had done for me.
Would you recognize this email if I showed it to you today?
I would.
Your Honor, I have Exhibit 3. I'm showing opposing counsel the copy that will be provided to the witness. Would opposing counsel like a copy?
Yes, please. Thank you.
Would Your Honor like a copy?
I have copies of the exhibits. Thank you.
Thank you.
No problem. Mr. Morrell, do you recognize this document?
Yes, this is the email that I sent Casey and then Casey's response.
And is this a fair and accurate copy of those two emails?
It is.
Your Honor, at this time, the plaintiff moves to enter Exhibit 3, the email exchange, into evidence.
Any objection from the defense?
Yes, Your Honor, to hearsay as to Silva Morell's statements.
Your Honor, the statements made by Silva Morell will not be offered for the truth of the matter. They are just there to show the response of Casey Porcini. There will be no questions on Silva's own words.
May I be heard, Your Honor?
May.
Pursuant to the supplement in today's case, there are to be no redacted copies provided to the witness or provided to the jury. Your Honor, this is still, the statements of Silva Morell are still hearsay, and it would be prejudicial for the jury to be able to see this evidence, especially as it's prohibited under the supplement.
Your Honor, we are not asking that any statements be redacted. The statements made by Silva Morell are not being offered for the truth of the matter and will not be questioned upon today.
Your Honor, if I may?
One more time.
The jury will still be able to see the entirety of this document, including Silva Morell's response. It's the defense's contention that this would unfairly prejudice them.
I will admit the document under these circumstances. It cannot be published to the jury. Rather, the plaintiff may use it for statements made by Casey Porcini and may not refer in any way to in the email to the statements of Silva Morell because they are precluded as hearsay statements.
Yes, Your Honor.
Now, Mr. Morell, I'd like to direct your attention to the second paragraph of Casey's email. Could you read beginning with, "I got your back"?
I got your back as long as you will always have mine. There will come a time when this makes sense for sure, but just remember that this is the way corporate politics works.
Did you understand what Casey meant at this point in time?
Well, of course I meant what it means to have someone's back, but I really didn't understand why Casey was saying this to me.
Now, what happened after you received this email?
After I received the email, I was invited by Casey to join her and a few other executives from Tigertail on a business mission to Xanadu.
What was the purpose of this trip?
The purpose of this trip was to attempt to get Tiger Mix into the European Union. The making of Tiger Mix requires the usage of a genetically modified organism, or GMO, and the process to get one of these items sold in European markets is very lengthy, and quite frankly, Tigertail just didn't have the time for it. So what the company was attempting to do was go through a small country like Xanadu, get it labeled as a non-GMO, and as Xanadu is a part of the European Union, it could be sold throughout the entire European Union, and thus Tiger Mix was in.
Could you explain what happened on the first day of this trip?
On the first day of the trip, we met with a few of the high-ranking officials of Xanadu, including Mr. Henri Bouton, and did a presentation on the benefits of having Tiger Mix within the European Union. Casey did mainly the most of the presentation, but after a while, I was actually able to take over and finish it.
What happened the following day?
On the next day, Casey invited Mr. Bouton to a private meeting, a kind of follow-up to what we had discussed the previous day. And Casey invited me to join along. When we arrived at a small cafe on the outskirts of town, Casey offered Mr. Bouton a bribe.
Objection, Your Honor, to lack of foundation.
Counsel?
Your Honor, as my witness attended this meeting, anything that occurred during this meeting he would have the knowledge for, and thus there is no lack of foundation.
May it be heard, Your Honor?
You may.
Your Honor, we've got two expert witnesses today who will testify whether or not a bribe actually occurred. This witness just said that Casey offered a bribe without giving any kind of foundation as to how he came to that conclusion, not what anyone said or anyone did.
May I respond, Your Honor?
You may. One more time.
Part of the burden of the plaintiff is to prove that Mr. Morell engaged in a protected activity, as Mr. Morell believed to a reasonable degree that Ms. Porcini did in fact offer a bribe. This statement does go to our burden, which would prove that Silva Morell engaged in a protected activity.
I understand, counsel, but I'm going to sustain the objection from this standpoint. This is, in effect, a perception in the form of a lay opinion by a witness. It can be offered provided that there's adequate foundation laid.
Yes, Your Honor.
Yes, Your Honor.
What was your perception of what happened at this meeting?
So when we got to the meeting, Casey started off very bluntly and asked Mr. Bouton what it would take to get Tiger Mix into the European Union. Originally, Mr. Bouton seemed confused at this, and then Casey directly offered the bribe of $5 million to Mr. Bouton.
Did anything else happen at this meeting?
After they went through everything that would happen, there was this handshake between the two of them. And this really struck me as odd, but I feel like it would be better if I could just show you why.
Your Honor, may the witness step down from the stand for the purpose of a demonstration.
You may. Counsel can reposition herself so that you can see.
Now, Mr. Morrell, could you demonstrate why this was odd to you?
Sure. Within Xanaduian culture, it's customary in the place of a handshake for each person to clasp the other's forearm. But what happened at this business meeting in Xanadu was that Casey and Mr. Bertone shook hands, as in a typical American-style business deal, and then Mr.
Objection, Your Honor, to improper opinion.
Your Honor, once again, part of the burden of the plaintiff is to prove that Mr. Morrell engaged in a protected activity. Mr. Morrell, seeing as a handshake went down, did in fact believe that a business deal had occurred and thus reported the bribe. Therefore, it meets our burden of proof today.
May I be heard, Your Honor?
You may.
Your Honor, this witness did testify that there was a handshake, but he went further beyond this testimony to make an opinion about what regularly occurs in business in Xanadu and what regularly occurs in the United States. Your Honor, this witness left Xanadu at age 18. He wouldn't know the customary business practices of that country compared to the customary business practices of the United States.
May I respond, Your Honor?
One more time.
As my witness did live in Xanadu for 18 years of his life, he would know primarily what the typical greetings and gestures would mean, seeing as he was a business person with the company of Tigertail Technologies. He would know the customs of what would happen in a business deal.
May I be heard, Your Honor?
No, we've had enough argument back and forth. I'm going to overrule your objection and permit the witness to testify, but I'm going to give you a great leeway in terms of cross-examining the witness on this subject.
Yes, Your Honor.
Thank you.
Did anything else occur after the handshake?
After the handshake happened, Casey, we got back in the car, and Casey told me that to keep quiet about what happened at the meeting under threat of my employment in America.
Thank you. You can return to your seat. Mr. Morrell, what happened once you arrived home from Xanadu?
When I arrived home, I was immediately praised for all of the work I had done on the trip. I was even put on the cover of the company's webpage, shaking hands with the Duke of Xanadu.
Mr. Morrell, did you have Casey's back and keep quiet about the bribe?
No, I did not. After about 2 weeks of feeling guilty and anxious over what I had seen happen, I did report the bribe to the company's lawyer, Riley Inoki.
Why did you feel comfortable reporting the bribe?
Under Pennsylvania law, there is an act known as the Whistleblower Protection Act. And what this law does is guarantee that someone who blows the whistle on a corrupt business act...
Objection, Your Honor, to improper opinion.
Counsel?
As the witness is the plaintiff in the case, he would have a knowledge of what the case is about, as he was also a member of Tigertail Technologies, who has a policy called See Something, Say Something. He would be familiar with the similarities between the See Something, Say Something Act and the Whistleblower Protection Act.
May I be heard, Your Honor?
Yes.
Your Honor, the plaintiff did bring this case to trial, but Your Honor, it's the job of the attorneys to characterize the law, and this witness is characterizing the law improperly. He's not an expert in this field, and that is reserved for legal argument.
I'm going to sustain the objection. It's the court's obligation to instruct the jury on the law, not a witness. Therefore, I'm going to preclude this witness from testifying with regard to what the law is and how it applies to this case. So you can continue.
Motion to strike that testimony?
So granted.
What were the results of the investigation?
The results of the investigation with Riley were that there was not enough evidence to bring a case against Tigertail. So I went to the Security and Exchange Commissions and reported the bribe there.
How were you treated after you reported the bribe?
After I reported the bribe, I felt isolated from the friends I had made at the company and even the work I had been doing. Instead of the typical engineering work that I had been doing my entire summer internship, I was given filing to do.
Mr. Morrell, are you still working for Tigertail Technologies?
No, I'm not. After my summer internship ended in 2014 and I went through my senior year at Calmia and graduated, I was informed by the company that my offer to the Leadership Development Program had been rescinded, and as they gave me absolutely no time to find alternative employment so that I could actually stay in the States, I was forced to return to Xanadu.
Objection, Your Honor, to more prejudicial than probative.
You're making an objection under Rule 403?
Yes, Your Honor. May I be heard?
You may.
Your Honor, this trial only concerns liability, not damages, whether or not TTT actually did retaliate against Mr. Morel. Your Honor, Mr. Morel is testifying that because of him losing his offer, he then had to return to Xanadu and he did not have a visa. Your Honor, that only goes to damages and only serves to prejudice the jury against TTT.
Well, counsel, are you arguing more prejudicial than probative, or are you arguing relevance?
Your Honor, I'm arguing that the relevance of this testimony is outweighed by its prejudicial value.
Okay. Counsel?
Your Honor, this is more probative than it is prejudicial. Seeing as though my witness does not work for Tigertail Technologies anymore, it is beneficial for the jury to understand where he is working and living currently, seeing as though he is not a member of Tigertail anymore.
How is that relevant, counsel?
The jury would need to understand why my witness decided to sue Tigertail Technologies in response to their firing him.
May I be heard, Your Honor?
Yes.
Your Honor, the witness did testify that he lost his offer. There's no objection to that. However, it's going beyond the scope of that and testifying to prejudicial information.
Very tenuous. It's borderline. I'm going to allow the answer to stand, but move on, counsel.
Yes, Your Honor.
Why had Tigertail claimed they rescinded your offer?
Tigertail claimed they rescinded my offer due to my inability to keep trade secrets.
Mr. Morel, did you ever divulge any trade secrets?
I did not. The only secret that I told was the bribe.
Thank you. I have no further questions, Your Honor.
Are you ready to cross-examine?
Yes, Your Honor.
You may proceed.
May it please the Court?
Proceed. Thank you.
Now, Mr. Morel, you were an intern at Tigertail Technologies, right?
Yes, I was an intern in the summer of 2014.
But you wanted to be more, right?
Yes, I thought I worked hard enough to attain a very good position within the company.
Right. You would have done anything to make your American dream come true, right?
Of course I would have.
Right. You didn't care about your fellow interns, did you?
Well, of course I cared about them, but I didn't care about the competition.
Well, in your own words, you didn't care if your behavior upset them. Those are your words?
Yes.
And we can agree that you didn't get along with some of them, right?
I got along with a lot of them, but a few I didn't get along with, yes.
We can agree you called your Irish colleague a Lucky Charms reject?
Yes.
Objection, Your Honor. Relevance?
May I be heard, Your Honor?
You may.
It's the defense's contention that Mr. Morel lost his offer because he wasn't fit to work at the company. I believe that having a contentious relationship with his coworkers would be sufficient evidence to meet our burden.
May I respond, Your Honor?
You may.
My witness calling another intern a Lucky Charms reject in no way impacts the burden of today's case. In no way does him having a disagreement with another intern show why he was fired.
Counsel, your objection is overruled. This evidence goes to a possible legitimate purpose for his termination and his proper cross-examination. I'm going to allow it to stand.
So, sir, you called my client, you called Silva Morel a Lucky Charms reject?
I did call Patty Straw a Lucky Charms reject, but I did have many friends among the interns. Patty Straw and I never got along.
So you did have a contentious relationship with Patty Straw?
Yes.
Well, now, I want to talk more about the LDP. You got that position in July of 2014?
I was emailed by the company's CEO informing me that I would be on their official list.
Well, you just said that you would be on their official list, but we can agree that it was actually unofficial, right?
Yes, the offer at the time was unofficial, but I was informed I would be on the list.
So it was unofficial?
Yes, but I would be on the official list.
It wasn't guaranteed?
No.
It was contingent on you being a good employee, right?
I'm sure.
And we can agree that after you received this offer, your boss actually told you to be careful with your pranks, right?
Yes, she did tell me to be careful with the pranks, which I heeded.
Well, now I want to talk about what happened after you were told to be careful. I want to talk about that trip to Xanadu. Now, on direct, you talked about a meeting with Henri Bouton and Casey Percini, yes?
Yes.
Now, I want to talk about what happened that night, what you didn't mention on direct. You were invited to a business reception?
Yes, following the 2 days of business meetings, we were invited to a reception.
Xanaduan executives were present at this reception?
Yes, everyone that had been involved with the actual business meeting.
And so we can agree that at that reception, you got wasted, didn't you?
I believe that I did become a bit too intoxicated. I was feeling many different emotions of guilt and anxiety over what Casey had told me and what was
Objection,
happening.
Your Honor, to non-responsive.
Your Honor, my witness answered the question. Pursuant to the rules of competition, he is allowed a brief explanation with his yes or no answer.
May I be heard, Your Honor?
You may.
My simple question was that he did, in fact, get intoxicated. Your Honor, there's a redirect examination for him to go beyond the scope of that, but this witness was testifying about what he heard earlier, what he saw earlier, what Casey said, what he felt.
Well, counsel, in any situation, once a witness answers a question, he is permitted to explain. Now, if he begins to filibuster, it may be appropriate to object at that point, but I'm going to allow him a brief explanation of his answer. Okay?
So, Mr. Morell, you did get wasted at this meeting?
I wouldn't say I was wasted, but I was a bit too intoxicated.
Well, sir, you actually don't remember the night, do you?
No, I don't remember much of it. I do regret the offenses I gave if I did.
You don't remember what you drank?
No, I drank Xanadu and sours.
Well, you don't remember how much you drank, right?
Not very much, no.
You don't remember who you talked to?
No, I can't remember much of the night, but it must not have mattered in the end because the deal did go through and I was never reprimanded.
Sir, I wasn't asking about whether you believe it mattered. I'm simply asking. You don't remember one thing about that night.
No, I can't remember the night.
And we can agree that you probably offended people, right?
I could have said a lot of different things to a lot of people. It might have been offensive.
You actually probably could have said some stupid things to the wrong people, right?
That's true.
Now, I want to talk about what you did when you returned. You wanted to make things better with your boss, right?
Yes, I felt like Casey and I had become distant.
So you decided to pull another prank.
Yes, Casey and I were pretty good friends.
So you broke into Casey's office, right?
Yes, I went into Casey's office before she got to work and put sticky notes all around the office. It's kind of a lighthearted prank.
And sitting on Casey's desk were TTT's 5-year expansion plan, right?
I don't know what was on Casey's desk. When I actually went into the room, I did see a binder on the desk, but I assumed it was just Casey's usual work, so I didn't want to look through any of her private stuff.
But eventually you learned that it was TTT's 5-year business plan, right?
I was told of some rumors going around, but I have no idea for certain what was on the desk.
We can agree you posted that video online?
Yes, I have a YouTube channel called Xanadu Got You that I started back in Xanadu, and I post all my prank videos. This one.
And that video, with documents on her desk, got 45,000 views. Is that right?
Yes, I thought it was a pretty good video.
And we can agree that you pulled this prank after your boss told you to be careful. Yes or no?
Yes.
Thank you, Mr. Morell. Nothing further.
Any redirect?
No, Your Honor.
Okay, the witness may step down. Is the plaintiff ready to call his next witness?
Yes, Your Honor. The plaintiff calls Madison Blewett to the stand.
As soon as the witness is seated, you can proceed.
Yes, Your Honor. Good afternoon. Can you please introduce yourself to the jury?
Hi, my name is Madison Blewett.
Miss Blewett, are you currently employed?
Yes, currently I am the Director of Human Relations at the Tigertail Technologies plant in Whistleblower, Pennsylvania.
And for how long have you held this position at Tigertail?
I have been with the company since September of 2010, so almost 8 years now.
What exactly does your job entail, Miss Blewett?
My favorite part of my job is being the intern coordinator, which means that I recruit all of our interns, help them assimilate with the company, and make sure that they find success.
As the person to recruit the interns, do you know Mr. Silva Morell?
Yes, I do. I personally hired Silva.
Why did you decide to hire Mr. Morell?
To put it simply, he was perfect for the job. He had impeccable grades and one of the best international business...
Based on hearsay?
I'm sorry, what's your objection?
Based on hearsay?
Counsel?
Your Honor, I am unsure of what portion of this witness's testimony is considered to be hearsay.
I can explain, Your Honor. The grades Ms. Blewett is referring to are out-of-court statements being used to show the truth of the matter asserted, that Ms. Morell was indeed the perfect candidate. Those are hearsay.
May I respond, Your Honor?
You may.
These statements, which are indirect at best, are going to show subsequent action taken by the company. Seeing as though these stellar grades and incredible work performance
caused Ms. Blewett to hire Mr. Morrell, this shows subsequent action, therefore is not hearsay.
If I may respond, Your Honor, this witness just testified that Ms. Morrell was the perfect candidate for the job and then used the grades to back that up. Therefore, they are being used to prove the truth of the matter asserted, and therefore her conclusion is based on hearsay.
May I respond, Your Honor?
One more time.
These statements, once again, are being used to show subsequent action taken by the company. Therefore, they fall under a hearsay exception and can be offered for the truth of the matter.
I think your objection is very well taken, counsel. I think it's a very close question. I'm going to allow the testimony to come in and overrule your objection with regard to the grades being used as a basis based upon plaintiff's counsel's statement.
Yes, Your Honor.
You can continue.
Ms. Blewett, why did you hire Mr. Morrell to Tigertail Technologies?
He had wonderful grades in one of the most competitive international business programs in the world. He was well-traveled. He could speak 2 languages. And he sounds great on paper, but believe it or not, he was even better in real life. Silva's interviews was one of the strongest that I've ever seen performed, and it definitely proved that he would be a great addition to the Tigertail team.
Ms. Blewett, did Silva live up to your expectations while on the job?
Most definitely. From the moment he started working with us, I believe he was the hardest working employee that we had. Not only did he know how to work hard, but he also knew how to have fun. He had a YouTube channel where he would post videos of pranks that he would pull around the office.
Ms. Blewett, I'd like to talk about the company's trip to Xanadu. Can you please explain to the jury what this trip was?
Yes, in mid-July of 2014, our company went on a trade mission to Xanadu in an attempt to get Tiger Mix named as a non-GMO.
Following this trip, Ms. Blewett, how was Silva Morrell's work around the office?
I didn't think that Silva's quality of work changed at all following the Xanadu trip, but our senior management suddenly started giving him some very low evaluation scores.
You just mentioned scores. What are these exactly?
We give our interns a weekly performance evaluation score on a scale of 1 to 10.
And who inputs these scores into the computer?
I'm the one who puts the scores into our computer system after receiving them from our senior management.
Would you recognize a copy of Silva Morrell's score report in court today?
Yes, I would.
Your Honor, I'm approaching the witness with what has been previously marked as Exhibit 6, Silva's score report. I'm showing opposing counsel a copy. I'll be offering the witness. Would opposing counsel like a copy?
Yes, please.
Would Your Honor like a copy?
I have a copy, thank you.
Here you go. Ms. Blewett, do you recognize this document?
Yes, this is Silva's intern performance summary report from his time with the company in 2014.
Is this a fair and accurate copy of the original document?
Yes, it is.
Your Honor, the plaintiff now moves to enter Exhibit 6, Silva Morrell's score report, into evidence.
Counsel?
No objections, Your Honor.
Exhibit 6 is admitted without objection.
Your Honor, at this time, the plaintiff asks permission to publish Exhibit 6 to the jury.
You may.
Ms. Blewett, can you please explain to the jury a little bit about how this document is set up on this page?
Yes, of course. The far left column is the project dates column, which lists each of the weeks that our interns spent with the company. The center column is the score that they received on a scale of 1 to 10, with 10 being the highest. And this is where it can get a little confusing, the reporter column. Since I'm the one who receives the scores from our senior management to put into our computer system, when I do so, my name is saved as the reporter. If another one of our senior management officials goes into this document and either views or changes these scores after I have initially submitted them, then their name is saved in place of mine as the reporter.
Ms. Blewett, what are Silva's first 3 scores on this sheet?
From his first 3 weeks with the company, Silva received an 8, a 9, and a 10.
Following the Xanadu trip, what are Silva's next 3 scores?
Following the Xanadu trip, which would be project date number 10, July 21st through July 25th, Silva received a 2, a 6, and another 2.
Ms. Blewett, looking down at every score on this sheet, are these the scores you remember putting into the computer?
No, actually, there are several scores previous to the Xanadu trip that have been changed.
And after everything that happened...
Your Honor, lack of foundation?
Your Honor, this witness has previously testified to being the person to input each of these scores on a weekly basis. This witness has more than enough knowledge to testify to the contents of this document.
Counsel's objection is that you haven't laid that foundation to acquire the testimony, so I'm going to sustain it, but permit you to ask some additional questions so that she can make that statement, if possible.
Yes, Your Honor. Ms. Blewett, who enters these scores?
I'm the one who puts the scores into our computer system, and as I remember, Silva received very high scores throughout his internship leading up to the Xanadu trip. Looking at this document now, there are several scores previous to the Xanadu trip that have been lowered.
Objection, Your Honor. Speculation, if I may elaborate.
You may.
This witness has not provided any foundation as to whether or not the scores were actually changed. She is simply saying they were changed without showing any evidence of that occurring.
May I respond, Your Honor?
You may.
Under Rule 701A, this witness is entitled to her rationally based perception. This witness has just testified to entering every score on the sheet, and these are not the scores she remembers. Additionally, opposing counsel's argument goes to the weight rather than the admissibility of this document.
If I may respond, Your Honor, this witness specifically testified that they were, in fact, changed, but has provided no evidence to show that that is actually the case. They're speculating to the fact whether or not these were changed.
I'm going to allow the testimony to stand and overrule your objection from this standpoint. She's testified that she's entered every score, and they're not consistent with what she's entered. Your objection does go more to the weight rather than the admissibility of the evidence, but I'll certainly permit you to cross-examine this witness thoroughly on this issue. Thank you.
Yes, Your Honor.
You can continue.
Ms. Blewett, are these the scores you remember?
No.
And after everything that happened, was Silva hired by Tigertail Technologies?
No, unfortunately, Silva's offer of employment was rescinded in May of 2015.
Was this notable to you in any way?
Yes, I thought it was very odd that they rescinded the offer without consulting HR first, but what I thought was even more odd was that they waited so long to notify Silva, whereas usually if we're letting an
Objection,
employee
Your
go...
Honor. More prejudicial than probative.
There's an objection under Rule 403, Counsel.
Your Honor, this testimony is far more probative than prejudicial. This statement, as the human relations officer at the company, is stating why the company waited so long. Additionally, this goes to show our burden today, as we are testifying that Tigertail Technologies wrongfully terminated Silva Morel under false pretenses, and therefore, this is far more probative than prejudicial today.
If I may respond, Your Honor.
One more time.
This trial is about liability, not damages. Ms. Blewett testifying to Mr. Morel receiving harsh punishment due to the time at which it was rescinded goes more to the damages than it does the liability, and therefore the prejudicial value outweighs the probative value.
I think it is relevant to the issue of the reason for the individual not being offered the job or being terminated. Therefore, I'm going to overrule your objection.
Yes, Your Honor.
You can continue.
Ms. Blewett, was proper protocol followed in not hiring Mr. Morel?
No, normally when we're letting an employee go, we give them as much notice as possible so that they can find a new job, or in Silva's case, a new visa sponsorship, but the company chose to wait, and Silva was forced to return to Xanadu.
Thank you, Ms. Blewett. Your Honor, I have no further questions at this time.
Okay. You may cross-examine.
Yes, Your Honor. May I proceed?
You may.
Ms. Blewett, we can agree that from the very beginning, Silva Morel was violating company policy, right?
Yes, technically, it's against our company's policy to post videos and photos from inside the workplace, but our senior management had absolutely no issue with these videos being posted. In fact, they encouraged them, and we would watch the videos at work, send them around.
Ms. Blewett, I didn't ask you about any exceptions. I'm simply asking, from the very beginning, Silva Morel was violating TTT's social media policy, yes or no?
Yes, but our senior management was willing to make an exception with Silva.
Ms. Morel also violated TTT's moonlighting policy, right?
No, Silva was not in any violation of our moonlighting policy. We do have a policy set in place where one cannot have another job while an employee of Tigertail, but Silva made some ad revenue from YouTube videos, but it wasn't nearly a substantial enough amount to be considered a second job.
I'm not asking you considering it. So just to be clear, the policy was that you cannot have another job while currently employed, right?
Yes.
And Ms. Morel made ad revenue off her YouTube channel, yes or no?
Yes, but we never considered YouTube a second job.
Now, you talked about Ms. Morel being sent on a trip to Xanadu on direct examination, correct?
Yes.
This was one of the most important trips in company history, right?
Yes, it was an important trip.
You also figured it was being used as a test, didn't you?
Yes, when we set our interns, our most important part of having an internship program is preparing our interns to perform business in real-life situations like the Xanadu trip.
So it was being used as a test between Patty Straw and Silva Morel, wasn't it?
Yes, both of them were invited on the trip.
And both received a performance evaluation for this trip, right?
Yes.
Patty Straw's was above average, wasn't it?
Yes.
However, Silva Morell's was extremely poor, right?
Yes, and this shocked me because from what I heard, Silva had performed wonderfully on the Xanadu trip. In fact, I read a press release that quoted Casey saying how well Silva did.
Objection, Your Honor. Under Rule 6.24, the witness is entitled to a brief explanation of the answer. I ask the opposing counsel allow my witness to finish testifying.
I will, counsel, but your witness has to stop filibustering.
Yes, Your Honor.
Okay? You can continue.
So just to be clear, Silva Morell received an extremely poor evaluation for this trip, right?
Yes.
Now, I'd like to talk to you about Miss Morell's behavior in the workplace. She once played a prank on Casey Porcini, right?
Yes.
She went into her office,
Correct.
covered in sticky notes,
Yes.
and he recorded this prank, didn't he?
Yes.
He posted it to his YouTube channel.
Mm-hmm.
So again, Mr. Morell violated TTT's social media policy, didn't he?
Yes, but once again, we were willing to make an exception to this rule.
And just to be clear, this prank was recorded in the office of a level 5 senior executive, right?
Yes, it was.
And at least 45,000 people saw that video, didn't they?
Yes.
Now finally, Ms. Blewett, let's discuss the Leadership Development Program. When April of 2015 came around, Silva Morell was denied entrance into the LDP, correct?
Yes.
Except he had fierce competition for that spot, didn't he?
Yes, this is a very coveted spot that I believe Silva deserved.
There was competition between Patty Straw and Silva Morell, wasn't there?
Yes, Patty and Silva were our two sort of front runners.
Right, both were at the top of their class of interns, weren't they?
Yes, but Silva was always a step above Patty.
Well, to the best of your knowledge, Patty Straw was never considered a subpar employee, was she?
No, Silva wasn't either.
You say that, but that's not true. Silva Morell was considered a subpar employee, wasn't she?
When we started looking at our evaluations to see who would be admitted into the Leadership Development Program, and we referenced the intern performance summary reports and the low scores were present, that's when Silva began to be referenced as subpar.
But she was considered a subpar employee, right?
By some, but not by me.
Well, let's also talk about what Patty Straw didn't do. Patty Straw never posted images of the workplace online, right?
I can't testify to that.
Patty Straw didn't violate company policy in 2 different ways, right?
Objection, Your Honor. Asking questions outside the scope of this witness's statement.
If I may respond, Your Honor, if a witness chooses not to include something in their affidavit, it is considered a material absence, and therefore the witness cannot invent it on the stand. If it's absent in their affidavit, they cannot make something up on the stand, but they can be asked about it.
May I respond, Your Honor?
May.
By that definition, the witness is entitled to make up any answer they see fit, seeing as though it is not within their witness statement, it is outside the scope of their statement, and therefore she may answer in any manner, as the door has been opened.
If I may respond, Your Honor, the witness, if it's absent in the witness's affidavit, they must answer with a no, as it did not happen if it's a material absence in the affidavit. They cannot invent facts on the stand.
Where is that in the materials, counsel?
It's in the rules, if I may have a moment, Your Honor.
You may, briefly.
One moment, Your Honor. Your Honor, pursuant to the mock trial rules of competitions, Rule 4.6, it is presumed that a witness has identified each material action that the witness took and each material fact that the witness considered. Accordingly, a witness who has not identified an action taken or a fact considered in his or her statement may not, upon cross-examination, claim to have taken material action or considered a material fact. If this witness is silent about it in their affidavit, they can't testify to not doing it on cross-examination.
Based upon that, I'm going to overrule your objection, counsel.
So Patty Straw never violated company policy in 2 different ways, right?
I'm not sure.
Patty Straw never received numerous poor performance reviews, right?
Once again, I can't say that that's true.
Ms. Blewett, you say that you don't know if that's true or not, but you oversaw the development of all of your interns, right?
Yes.
And Patty Straw was one of these interns, correct?
Yes.
So Patty Straw never violated company policy on 2 accounts.
Not that I'm aware of, no.
Patty Straw didn't receive an extremely poor review for the trip to Xanadu, right?
No.
Patty Straw didn't pull pranks around the office.
No, Patty did not.
Patty Straw was never removed from important projects.
No.
Patty Straw didn't received numerous poor performance reviews, right?
True.
And just to be clear for this jury, it was Patty Straw who was ultimately given the position in the LDP, wasn't it?
Yes, and this was following a meeting that we had with Casey.
Objection, Your Honor. Non-responsive. I didn't ask anything about a meeting, and this witness is going on to testify about that.
Counsel?
Your Honor, under Rule 6.24, a yes or no answer is to be accompanied by a brief explanation. This witness had barely said more than 3 words before opposing counsel interrupted her.
Your Honor, if I may respond?
You may.
The explanation the witness was giving had no relation to my question. I simply asked whether or not Patty Straw was hired, not anything about a meeting. That's grounds for redirect examination.
Well, counsel, I didn't gather enough from what she was going to say as to whether it was responsive or not. She did give you a yes answer and was in the process of explaining it. So I'm going to give her some leeway in terms of explaining it. So I'm going to sustain the objection, and I'm going to allow her to briefly explain without filibustering. Okay?
Yes, Your Honor.
Thank you.
So just to be clear, Patty Straw didn't do any of those things, and she's the one that got the job.
That's correct.
Thank you. Nothing further, Your Honor.
Do you have redirect?
Yes, Your Honor.
You may proceed.
Ms. Straw, opposing counsel had a lot of questions about what Patty Straw did or did not do. Did Patty Straw report a bribe?
No, Patty Straw never reported any bribe.
Your Honor, I have no further questions.
Any recross based upon that?
No recross, Your Honor.
Okay, the witness can step down. Is the plaintiff ready to call its next witness, or his next witness?
Yes, Your Honor. The plaintiff calls Harley Agarikis to the stand.
Okay. And proceed as soon as the witness is ready.
Good afternoon. Could you please introduce yourself to the court?
Hello, my name is Special Agent Harley Agarikis.
And Mr. Agarikis, where are you currently employed?
I am a senior principal investigator with the Securities and Exchange Commission.
And where did you work before this?
I worked at H&R Block during my college days, as well as being a tax preparer in New Jersey for a decade.
Could you describe any experience that you have with forensic accounting?
I worked as an accountant for 10 years, as well as a junior analyst with the SEC in their forensic accounting department prior to my current position. I also have a master's degree in forensic accounting from Villanova University.
You just mentioned that you work with the SEC. How did you get involved there?
In 1999, I was working for a local power company by the name of Atlantic City Electric. And I noticed that the reports we were getting from our power broker, a company called Enron, weren't adding up. So I tried to crunch the numbers, and when I couldn't make them work, I got in contact with the SEC. They were very impressed with my work because I came to the same conclusions that they did with only a fraction of the numbers. So they offered me a position.
Your Honor, the plaintiff now moves to enter Harley Agarikis as an expert in forensic accounting under Rule 702.
Any objection or dear?
Yes, Your Honor, to lack of foundation. If I may elaborate.
You may.
Pursuant to Rule 702, in order for a witness to be qualified as an expert, the witness must testify as to if they rendered an opinion, how they rendered that opinion, what materials they relied upon, and if the facts and data they relied upon are sufficient. Opposing counsel has not laid that foundation.
May I respond, Your Honor?
You may.
In pursuant to Rule 702, in order to be qualified as an expert, the witness must have testified to having experience, skill, knowledge, training, and expertise, and the witness has laid the foundation as to this, and therefore is qualified to be an expert in the field of forensic accounting in today's case.
Your Honor, if I may.
You may.
There are no objections to the expertise of this witness, but rather the foundation that Rule 702 requires as to how this witness rendered their opinion and what materials they relied upon.
Counsel, your objection is geared more towards not expertise, rather towards whether the opinion that the witness may or may not offer is proper, so that it's premature in that regard. I will recognize the witness as an expert in the field identified, or fields identified, and then the witness can give testimony regarding opinions, and if there's not a proper foundation at that point, you can again raise your objection.
Yes, Your Honor.
You can continue.
Mr. Agarikis, how did you first come into contact with Silva Morel?
So on August 18th of 2014, Around 6 a.m., I received a call from a very panic-sounding intern at the local company, Tigertail Technologies. This intern would reveal himself to be Silva Morel.
Your Honor, for hearsay.
May I respond, Your Honor?
You may.
Under Rule 703, which is the basis of an expert's testimony, this is going to show crucial information to the witness's investigation, which is how he came to his final conclusions, and therefore it is not hearsay.
Your Honor, if I may.
You may.
Experts cannot be used as a conduit to hearsay. They can only rely upon hearsay if the experts in the particular field would reasonably rely upon hearsay. This is being used to prove the truth of the matter asserted, that Silva Morel did in fact witness a bribe, and this witness is being used as a conduit to hearsay.
May I respond, Your Honor?
You may.
Furthermore, this is going to show the subsequent action of the witness, seeing as he conducted an investigation based off of Mr. Morel reporting the bribe to him, and therefore it is not hearsay.
Your Honor, if I may.
One more.
Before this witness was qualified as an expert, opposing counsel did not ask this witness as to what materials they relied upon. This witness has not laid the foundation that he relied upon Silva Morel's statements, and therefore he's being used as a conduit to hearsay.
Counsel, an expert witness under Rule 703 is permitted to rely upon hearsay evidence for purposes of rendering opinion. However, the expert is not allowed to be, as counsel has said, the conduit and recite hearsay statements that would otherwise not come in. To the extent that he may have relied upon statements of Silva Morel in rendering opinions, that's fine. But he cannot quote verbatim as to what she told him if it's hearsay testimony. So you can continue with that ruling.
Yes, sir.
Yes, Your Honor.
So, Mr. Agarikis, what resulted from this call?
Mr. Morel described to me that he had witnessed a bribe take place overseas, and the details of his story sounded plausible enough that I opened an investigation into Tigertail Technologies.
Now, you just mentioned a bribe. How would you be familiar with the processes that would go into a bribe?
The SEC trains all of its agents in ways to recognize typical patterns of bribery.
Could you elaborate a little bit on these typical patterns?
For smaller amounts of money, you would have methods.
Your Honor, to improper opinion.
Why is it improper, counsel?
Your Honor, this witness was entered as an expert in forensic accounting, not federal bribery standards or corruption practices, yet this witness is going on to testify about bribery standards.
May I respond, Your Honor?
You may.
In his investigation in forensic accounting, this did deal with the bribe that occurred. Furthermore, the witness has testified to having knowledge of bribes after being informed by the SEC where he worked. Therefore, the foundation has been laid that the witness would have this knowledge and be able to testify today.
Your Honor, if I may.
You may.
This witness is not entered as an expert in bribery standards, yet is going on to giving information about bribery standards that is outside of his expertise.
It's very well thought out objection. At this point, I'm going to overrule it and give this witness some brief leeway based on not only his experience in accounting, but also his experience with the SEC. I'm not going to let it go overboard, and you're permitted to again object, but he can give some opinions and information regarding this.
Yes, Your Honor.
Thank you. You can continue.
Mr. Agarikis, could you elaborate a little bit on the typical patterns of bribery?
For smaller amounts of money, there would be methods such as cash in an envelope being delivered. However, for a larger sum of money, such as the one that Mr. Morel described to me, there would be a typical two-meeting system. The first meeting would be a large social event where groups from both sides would get together, but nothing illegal would truly be discussed. However, later there would be a smaller, more private meeting, and this is where the bribe would be discussed by parties from both sides.
So having this knowledge, what was your initial reaction upon hearing Silva's story?
Mr. Morel's story fit what the SEC trained us to look for perfectly. It seemed to be a very textbook case right off the bat.
Now, Mr. Agarikis, you also mentioned that you launched an investigation. What did you discover at the start of this?
In the beginning of my investigation, I discovered that $5 million had gone missing from Casey Porcini's department. The money had been...
Objection, Your Honor, to lack of foundation.
May I respond, Your Honor?
You may.
The witness has testified to performing an investigation dealing with this, and therefore the foundation has been laid that in his investigation he would have come across this knowledge, and therefore it is admissible today.
Your Honor, if I may. The witness simply testified that he conducted an investigation and came across $5 million. However, he did not testify to how he came across this and how he would know what the amount of money this is, Your Honor.
Your objection is well taken. It's sustained.
Yes, Your Honor.
You can continue.
Mr. Agarikis, how did you come across your conclusions for the case today?
Tigertail was required to open its files and records to us, and when I was sifting through their banking records, I came across what I could only describe as $5 million being sent out of the company. It was being paid to 3 companies who had supposedly done work for Tigertail, and the 3 companies had put all the collective money into a single bank account on the island of San Lorenzo. I traced the money there, and after sifting through several years' worth of bank statements, I came across one that described the money being transferred in.
And would you recognize a copy of the statement today?
I would.
Your Honor, I have Exhibit 8. Let the record reflect that I am showing opposing counsel the copy that I will be providing to the witness. Would opposing counsel like a copy?
Yes.
Sorry. Could you please identify this document?
This is a bank statement from the San Lorenzo Federal Savings Bank.
And is this a fair and accurate copy of the statement?
It is.
Your Honor, the plaintiff now moves to enter Exhibit 8, the bank statement, into evidence.
Any objection?
No objections, Your Honor.
Exhibit 8 is admitted without objection.
At this time, the plaintiff asks to publish Exhibit 8 to the jury.
You may.
Mr. Agarikis, could you please elaborate on the information presented in this document?
This bank statement describes the transactions between the 3 companies of Marie Antoinette Consulting, Bastille Technologies, and Versailles Capital into this single account on the island of San Lorenzo. And as you can see, the final amount of money paid to them by Tigertail Technologies adds up to be $5 million.
And what did you discover about the 3 companies present?
All 3 companies were in fact fake, or the work product they had been paid for did not exist, such as Bastille Technologies, who had supposedly provided growth lamps for Tigertail's mushroom cultures. However, upon further investigation, the serial numbers on the lamps matched a delivery from a different local company who had already been paid.
So, after being in the bank account, what happened to the $5 million?
The $5 million disappeared from the account coincidentally at the same time that Mr. Henri Bouton was vacationing on the island of San Lorenzo.
So using all of the information that you collected in your investigation, what did you conclude happened?
I concluded that a bribe did in fact occur between Tigertail Technologies and Mr. Henri Bouton. The money was funneled into the account under the false pretenses of paying companies for work before it was taken by Mr. Bouton under the guise of being on vacation. It should be noted that Mr. Bouton and the money have not since been found.
Thank you. Your Honor, I have no further questions.
Thank you, counsel. The defense may cross-examine.
Yes, Your Honor. May I proceed, Your Honor?
May.
Sir, you're a senior principal investigator at the SEC, right?
That is correct.
We can agree that as a federal investigator, it's important to be reliable.
Of course it is.
It's important to be truthful.
Always.
But, sir, you weren't always truthful, right?
I've had some incidents. I've had a single incident in my past where I have made mistakes, yes.
Well, let's talk about that incident. The IRS subpoenaed documents from a few of your clients, right?
Over 30 years ago, I'd say, yes. During my college days, I helped some people dispose of subpoena documents for the IRS. It was a dumb mistake. I was young, and I was never officially punished for it, though I did end up having to do tax preparation in New Jersey.
Objection, Your Honor, to non-responsive.
May I respond, Your Honor?
May.
The witness has given an answer to the question asked and is simply giving his brief explanation that he is entitled to with his response.
Your Honor, if I may.
You may.
I simply asked this witness as to whether the IRS subpoenaed documents from his clients, but he went on to testifying to how old he was when this happened, what he did with those documents, and more answers that were outside the scope of my question, Your Honor.
May I respond, Your Honor?
One more time.
After directly answering the question asked, the witness is entitled to a brief explanation surrounding that question, and he has done so without exceeding that.
Your Honor, if I may.
One more time.
The witness is allowed a brief explanation, so as long as it is in the scope of the question, yet this witness continued to testify outside the scope of my question.
I believe his explanation to the point where the objection occurred was appropriate. A brief explanation, he will be allowed, not a filibuster. So permit him, you can re-ask the question and he can answer it one more time.
Yes, Your Honor.
Go ahead.
The IRS subpoenaed documents from a few of your clients, yes or no?
Yes, over 30 years ago during my college days, I was looking for quick money, and I did ultimately help some clients dispose of IRS subpoenaed documents.
Right, and because of this, the State Bar refused to let you become a licensed attorney. Is that right?
Objection, Your Honor. Relevance.
Your Honor, if I may.
You may.
Bias and credibility are always relevant. This is going to attack the witness's credibility, which is permissible under Rule 608.
May I respond, Your Honor?
May.
Seeing as this happened more than 20 years ago, it is not going to show the credibility of the witness. Furthermore, the witness being denied their attorney license has nothing to do with the investigation in today's case, seeing as it is in no way related to a field of law, and therefore it is not relevant in today's case.
Your Honor, if I may.
Plaintiff's counsel was arguing remoteness 30 years ago is a long time. Why should I let this in?
Well, Your Honor, opposing counsel is referring to Rule 609. However, under Rule 608, on cross-examination, it is permitted to question this witness on being truthful or untruthful, and this is what this line of questioning is going toward.
I understand that, but with the issue of remoteness, is there anything more recent that would show a pattern, or is this an isolated incident?
Your Honor, in the affidavit, there is no exact date as to when this happened. It simply happened in this witness's past.
Okay. He's stated that it happened 30 years ago. Is there anything in the affidavit about that?
No direct years, Your Honor.
May I respond, Your Honor?
May.
In the witness's statement, it says that whenever he's supposed to have subpoenaed documents, it was because of this that he was denied getting his attorney license, and therefore that date was given, and it was more than 20 years ago.
Your Honor, if I may.
May.
No exact date was given in the affidavit. It simply stated that this witness was going for his law degree.
I understand, but was it more than 20 years ago, counsel?
Your Honor, there is no exact date given.
Okay. Well, I'll permit you to pursue this if there is no exact date given.
Yes, Your Honor.
Okay, but if there is an exact date in the affidavit, I'm going to preclude it on the basis of remoteness.
Yes, Your Honor.
Okay.
Now, yes or no, the State Bar refused to let you become a licensed attorney. Is that right?
That's true, but ultimately I feel like that was the best decision for me because at my current position I feel like I'm able to make more of a difference in the business community.
But you can do so on redirect. Yes or no, the State Bar refused to let you become a licensed attorney.
That is true, yes.
Now, let's talk about the investigation you conducted. On August 18, Silva Morel called the SEC?
That is correct, yes. Silva contacted me by phone.
Right, he told you a bribe had occurred?
That is what Silva stated to me, yes.
And so you began to conduct an investigation, correct?
Yes, we take all claims of corrupt business practices at the SEC very seriously.
And you found various deposits made into a San Lorenzo bank account?
That is correct.
But we can agree that you don't know whether Casey Porcini made those transactions?
I cannot, but it came from Casey Porcini's department, and considering he was head of the division, she would have had to approve all outgoing funds.
Sir, you don't mention this in your affidavit, right?
No.
Now, you don't know whether this account is linked to an official in Xanadu?
It would seem to be more than coincidence that all the money disappeared from the account at the same time Mr. Bouton was vacationing on the island.
But, sir, you can't definitively tell this jury that Henri Bouton withdrew that money. Is that right?
There is no direct evidence.
In fact, TTT wasn't even charged for bribery, right?
No, they were charged for embezzlement, where they had to pay another $5 million.
And when this happened, you were mad, right?
Any professional would have somewhat of an emotional reaction when their conclusions are taken as something different.
That's a yes to my question?
Yes.
You lost your cool, right?
As I said, I had an emotional reaction because they were taking my conclusions and saying they were something else.
Because you think TTT are a bunch of crooks, right?
I would say that they are guilty of bribery, yes.
Now, sir, in your own words, TTT are crooks. Is that correct?
Yes, they were guilty of bribery, in my professional opinion.
And then after all of this, you were suspended from your job for a week. Is that correct?
My superiors, after coming under under significant political pressure from politicians linked with Tigertail Technologies, thought that my investigating was starting to look...
Sir, once again, I understand you'd like to explain, but yes or no, because of this, you were suspended from your job for a week. Is that right?
Yes, my superiors took me off the case after coming under significant political pressure from politicians linked with Tigertail Technologies.
Now, let's talk about Mr. Morell's role at TTT a little more in depth. You think that Mr. Morell's a good person, right?
I give everybody the benefit of the doubt.
But in your own words, Mr. Morell's a good person, correct?
Like I said, I give every person that comes to the office the benefit of the doubt of being a good person.
Now, you think he's an honest person, right?
Based off how I interacted with Mr. Morell, yes.
One that deserves whistleblower protection?
Anybody who participates in the Whistleblower Protection Act, someone who reports corrupt business transactions, deserves protection, yes.
But we can agree that you don't work at TTT, right?
No, I do not. I work with the Securities and Exchange Commission.
You don't know how Mr. Morell acted like in the workplace. Is that correct?
No, that's none of my business. I investigated Tigertail Technologies banking.
You don't know whether Mr. Morell acted unprofessionally?
That is no business of mine.
That's a yes to my question. You don't know?
No, I don't know.
You don't know whether Mr. Morell acted dishonestly?
Once again, that's none of my business and not my problem.
Sir, is that a yes to my question?
Yes.
You don't know whether Mr. Morell acted irresponsibly, right?
I don't know that, no.
Mr. Agaricus, for all you know, Mr. Morell's offer could have been rescinded because he wasn't fit to work at TTT. Is that right?
That could be the case. However, my role was the investigator, and from what I found, TTT violated the Foreign Corrupt Practices Act.
Sir, I wasn't asking you about the Foreign Corrupt Practices Act. I was simply asking you, for all you know, Mr. Morell's offer could have been rescinded because he wasn't fit to work at TTT. Yes, or no?
It very well could have been.
Thank you, Your Honor. No further questions.
Any redirect?
No, Your Honor.
The witness can step down. Does the plaintiff have any further witness?
No, Your Honor. At this time, the plaintiff rests their case in chief. However, pursuant to Rule 6.23, we ask the official timekeeper for the time remaining.
As is the defendant, Your Honor.
Okay.
The plaintiff has 12 minutes and 22 seconds left. And the defense has 14 minutes and 29 seconds left.
Thank you.
Okay. Give the scorers a chance to catch up here. Okay. Is the defense ready to proceed with its first witness?
Yes, Your Honor. The defense calls Casey Porcini to the stand.
All right.
May we proceed?
You may.
Could you please introduce yourself to the court?
Good afternoon. I'm Casey Porcini.
What do you do for a living, Miss Porcini?
After working for Tigertail Technologies, I opened an independent consulting firm based out of Chardonnay, France.
What kind of company is Tigertail Technologies?
TTT is a fun-loving company. Even though we're more Silicon Valley than Kennett Square, we still expect everyone to perform at their best.
What were your responsibilities at TTT?
As a business development manager, my main focus was on European expansion, but I also worked closely with our interns.
How many interns did you work with?
There were hundreds. However, two stood out above the rest, Patty Straw and Silva Morell.
Let's talk more about Silva Morell. What was your first impression of Silva Morell?
Silva showed so much potential, but he needed to rein in his exuberant personality. But I wanted to see him succeed, so I helped him with his visa.
How'd you do that?
I got him an invite to the Leadership Development Program. If he got in, he would be considered for an executive position, which meant TTT would sponsor his visa.
Miss Porcini, was this invite guaranteed?
It wasn't, and I said to Silva, listen, you need to be careful with the pranks. He would now be evaluated as an executive, not just another intern.
Did Mr. Morell meet those higher expectations?
Unfortunately, he didn't, and it started on the trip to Xanadu.
Let's talk about that trip. What was the purpose of the trip?
First and foremost, it was a trade mission, but also a test to see if Silva Morel and Patty Straw were executive material.
How did people react to Silva Morel being brought along on this trip?
Upper management expressed concern that he wasn't ready for a trip like this, but I asked him to stop pulling pranks, especially in Xanadu.
Who led the trip to Xanadu?
I did.
How did it begin?
On July 19th, we met with Xanadu's equivalent of the EPA, the Agency Notre Vard, or AN. Silva did so well that we had a press release written about it for when we returned.
Did you attend any other meetings on this trip?
Yes, the next day I woke up to a note from Henri Bouton, he's the director of the AN, inviting me to coffee. And I didn't know what a private meeting with him would mean, so I didn't say anything. But I did bring Silva to translate.
What happened at this meeting?
Henri Bouton asked me for a direct investment of $5 million.
Ms. Porcini, I just want to be clear for this jury. Who initiated the bribe?
Henri Bouton did. I was shocked, and I said to him that TTT is an American company, so there was no way that was happening.
What happened after you left this meeting?
I asked Silva not to say anything.
Why did you ask Silva Morel not to say anything?
He doesn't have experience in these situations. I do. And if word got out, it could cause an international incident.
How did Mr. Morel perform for the remainder of the trip?
He really let me down. He embarrassed the entire delegation at a reception.
What'd he do?
He would not stop drinking. He criticized the food, mocked the dance, and spilled a drink all over Henri Bouton's shoes. I was mortified.
What did you do when you returned to the United States?
The day we got back, on July 21st, I asked Madison Blewett to take him off all critical projects.
Why did you instruct Miss Blewett to do that?
I'm a believer in the three-strike method. People make mistakes, but the reception fiasco was strike number one, and I couldn't risk letting anything else go wrong.
When you instructed Miss Blewett to do this, did you know anything about blowing the whistle?
Absolutely not.
How did Mr. Morel perform for the rest of his internship?
We almost made it through without any more incidents, but then on his last day, he broke into my office, covered it in sticky notes, and filmed the whole thing.
Did you see the video?
Yes, he posted it online, and our entire company expansion plan is visible on my desk. That was strike number 2.
How'd you react to this?
I called Silva, and I asked that he take the video down, but he refused. Strike number 3.
Ms. Porcini, why wasn't Silva Morel given that position in the leadership development program?
I had high hopes for Silva. I wanted him to be an executive, but he had become a liability to the company. Patty Straw showed us she was simply more qualified and more professional, so she got the job.
Thank you. Nothing further, Your Honor.
Does plaintiff have cross-examination?
Yes, Your Honor.
You may proceed.
Ms. Porcini, when Silva first came to Tigertail, you were very impressed with his work ethic, weren't you?
Yes, he had this enthusiasm for innovation that was quite impressive.
In fact, as you mentioned on direct, you even emailed the company's CEO in order to help Silva get into the leadership development program, didn't you?
Yes, I really wanted to see him succeed.
And it was you who decided to invite Silva on the trip to Xanadu, correct?
Yes.
Now, while on this trip, you met privately with Mr. Henri Bouton, didn't you?
Yes, he had invited me to a private meeting.
And isn't it true that at this meeting, you asked Mr. Bouton what it would take to get Tiger Mix labeled as a non-GMO?
Yes, that was the point of the trip.
Now, after this meeting, you told Silva not to repeat what he saw, correct?
Yes, like I said on direct, he doesn't have experience in these situations, and I didn't want to cause some international incident.
Now, let's talk about that press release that you mentioned earlier. In this press release, you are quoted praising Silva, aren't you?
Yes, he performed very well at that initial meeting.
So you do admit that Silva did well on this trip, correct?
At the initial meeting, yes.
Now let's talk about these pranks that you mentioned earlier. You have previously encouraged Silva's pranks, hadn't you?
I I found them quite funny, actually. I liked them. I wouldn't say I encouraged them.
Now, with Silva's sticky note prank, you claim that trade secrets may have been exposed, correct?
Yes, our entire company expansion plan is visible on my desk in the video.
But Ms. Porcini, the video resolution was too low for anything to be seen. Isn't that true?
Objection, Your Honor. Argumentative.
Counsel?
Your Honor, I'm simply asking the witness if the video resolution was too low. I'm not arguing with her at all. I'm just asking her a question.
If I may respond, Your Honor.
Briefly.
The opposing counsel did not ask the witness a question. She just said to her, the video resolution was too low to read anything. That is not a question. That's a statement. She's providing an argument to the witness.
I disagree with you, counsel. I think it's a proper question. I'm going to overrule your objection.
Yes, Your Honor.
You may continue.
So the video resolution was too low for anything to be seen, correct?
Yes, that's true. However, that's not the point. TTT can't have an employee that puts their social media presence over their job constantly.
But Ms. Porcini, no trade secrets were ever exposed, were they?
I don't know. I mean, that video was seen by 85,000 people.
Now I'd like to talk about your current employment. You do not work for Tigertail Technologies anymore, do you?
No, I don't.
You were forced to leave because a large sum of money went missing from your department. Isn't that correct?
Yes.
And after this money went missing, Andre Batone declared that Tiger Mix was a non-GMO, didn't he?
I was just as surprised as everyone else was. When we left that trip, it seemed like the deal was never going to go through.
I have no further questions, Your Honor.
Thank you. Any redirect examination?
No redirect, Your Honor.
The witness may step down.
Thank you.
And the defense may call its next witness.
Your Honor, at this time, the defense calls Patty Straw to the stand.
Okay.
May I proceed, Your Honor?
May.
Could you please introduce yourself to the court?
Hi, my name is Patty Straw.
And Miss Straw, where are you originally from?
Believe it or not, I'm originally from County Mayo, Ireland. See, my mom's Irish, but my dad's African American, and I was raised in Ireland, so I closely identify with my Irish heritage.
And how do you know the plaintiff in today's case, Mr. Morell?
I went to County University, and so did Silva.
Were you and Silva friends?
I knew him, but I wouldn't say that we were friends. It was kind of hard for us to get close in college, considering that we were competitors.
Well, why do you say that?
Well, I'm a dual national, and I knew that if I wanted to make it in America, I'd have to work harder than everyone, including Silva. When we were both offered internships at TTT, the competition continued.
How did you react to receiving an internship?
I was so excited when I was accepted, but I also wanted to try for a full-time position, so I applied for TTT's Leadership Development Program.
And Ms. Straw, what happened when you went to TTT?
Well, I applied for the Leadership Development Program, but it was really competitive, so I figured that Silva would too, and I knew it would take a lot to beat him.
Why is that?
Well, Silva and I are completely different. He's funny and charming, and I can be a bit shy. But this motivated me to work even harder during the internship. But from what I could tell, Silva was more concerned with cheating and pranks.
Objection, Your Honor. Speculation.
Your Honor, if I may.
Yes.
This witness worked alongside Mr. Morell, was part of the internship program with Mr. Morell, and is testifying to her observations. When she looked at him, he would be cheating or pulling pranks.
May I respond, Your Honor? This witness has failed to lay any foundation of the sort which opposing counsel has just mentioned, and therefore, this is still speculation and is inadmissible today.
Your Honor, if I may, make an offer
of proof.
This witness will go on to testify, saying that she has evidence of both the cheating and the pranks. She's merely testifying to her own observations of what she saw Mr. Morell doing around the office.
Well, counsel, under Rule 701 of the Rules of Evidence, a lay witness is entitled to offer an opinion, but it has to be based upon perception and interaction. The witness has not laid the proper foundation for this testimony at this time, so I'm going to sustain the objection until such time as a proper foundation is laid.
Yes, Your Honor.
Your Honor, under Rule 611E, I ask that this testimony is stricken from the record at this time.
It will be stricken at this point without prejudice to be readmitted if proper foundation is laid.
Yes, Your Honor.
Thank you.
Now, Ms. Straw, you just accused Mr. Morrell of cheating. Do you have any evidence of this cheating?
Yes, I do. I saw an analysis that another intern, Shanty, was working on. And only a couple of days later, Silva handed in a report with Shanty's exact analysis on it.
Objection, Your Honor. This is hearsay.
Your Honor, if I may?
You may.
The witness has elicited no statement. Hearsay is an out-of-court statement used to prove the truth of the matter asserted. This witness is simply testifying to her observation.
May I respond, Your Honor?
May.
This witness is offering direct testimony in regards to documents that are made outside of the court. These statements from these documents are being offered for the truth of the matter asserted, and therefore are hearsay.
Your Honor, if I may?
One more time.
This witness is not testifying to any statements on the documents. She's simply testifying to what she saw occur with this document. She's not saying any statements that were on the document.
The objection is overruled. It's not a hearsay statement at this point. This is simply her observation.
Yes, Your Honor. Were you finished with your answer, Ms. Straw?
No. The analysis that I saw in Shanty's paper was on Silva's report just a couple of days later.
Now, earlier you mentioned that Mr. Morrell pulled pranks. What type of pranks would these include?
At first, the pranks were just silly. Like one time he covered my entire office in gift wrap. Although it was a bit annoying, it was just harmless fun. The issue is that the pranks started to get offensive.
Why is that?
It seemed as if Silva was picking fun at my Irish heritage. One day, he placed my stapler in a block of green gelatin, and on my birthday, he convinced everyone to speak in these terrible Irish accents. It was insulting. I don't even have an accent.
How did you react to all of these pranks?
Obviously, I was mad, but I tried not to let it get to me. I just figured that eventually Silva's actions would catch up with him. I'd say that they did.
Why do you say that?
Well, Silva and I were both asked to attend a huge trade mission to Xanadu. At first, he went to the meetings, and I stayed in the hotel doing research. The whole trip was going pretty well until the last night.
What happened on the last night?
Well, everyone that went to Xanadu was invited to this huge meeting with Xanaduan officials. I didn't want to drink that night, but when I looked at Silva, he just wouldn't stop drinking. He started insulting the people there and even spilled his drink on a high-level official.
What happened when you returned to TTT?
Riley Inoki and Casey Porcini called a meeting with the interns to talk about Silva's behavior. At first, no one spoke up, until I did.
Now, Ms. Straw, were you ever reprimanded for getting drunk?
No, I never got drunk.
Were you ever reprimanded for pulling pranks?
No, I didn't pull pranks in the office.
And Ms. Straw, which intern ultimately secured a position at TTT?
I did. I was the only intern offered a full-time position at TTT.
Thank you, Your Honor. Thank you, Ms. Straw. No further questions.
You may cross-examine.
Yes, Your Honor. May I proceed?
You may.
Ms. Straw, you've never liked Silva Morrell, have you?
No, not really. He always acted like he didn't have to work hard to get where he wanted.
You've even gone so far as to refer to Mr. Morrell as a leper, haven't you?
Yes, I did. Honestly, his pranks were offensive towards me and my heritage.
But you have called him a leper, correct?
Yes, I did.
You've also called Silva a thief, haven't you?
Yes, he constantly stole the other interns' work.
But, Ms. Straw, despite calling Silva a thief, you have stolen work from Silva, haven't you?
Once, yes, and I admit now that it probably wasn't the best way to handle the situation, but Silva did this all the time.
Regardless of what you believe Mr. Morrell did, you did steal work from Silva, correct?
One time, yes.
And despite your opinions of Silva, he was popular around the office, wasn't he?
I guess you could say that.
In fact, he was pulled into more meetings with company leadership than you were, wasn't he?
Yes, this was before the Xanadu trip, and obviously Silva would have more knowledge about Xanadu since he's from there.
But this upset you, didn't it?
Yes, it did. It seemed like Silva was only there as a translator.
And following the Xanadu trip, you mentioned that there was a meeting, correct?
Yes, there was, to talk about Silva's behavior.
And isn't it true that in this meeting, where Silva was not invited, you were the first to speak up, weren't you?
Yes, I thought that the other interns were too afraid to talk about what Silva had done.
So you were the first person to speak up about Mr. Morrell, correct?
Yes, I did.
In fact, you didn't hold back, did you?
Well, no, it was unfair that Silva would get away with cheating and pranks around the office. It was unprofessional.
despite your perception of Mr. Morel, isn't it true that he was praised for his efforts in Xanadu?
Yes, I believe he was.
Your Honor, I have no further questions at this time.
Thank you, counsel. Any redirect?
No redirect, Your Honor.
The witness may step down. Thank you. Does the defense have another witness?
Yes, Your Honor, but before we proceed, may we ask for a time check?
Quickly, it's my understanding you're permitted a time check, I believe, before your last witness.
Yes, Your Honor, before the last witness is here.
Thank you.
The defense has 5 minutes and 54 seconds left.
Thank you.
Thank you. You may call your witness now.
The defense calls Riley Inoki.
Okay. You may proceed.
Yes, Your Honor. Could you please introduce yourself to the members of the jury?
Good afternoon. My name is Riley Inoki.
What do you do for a living?
I'm currently the Vice President of Tigertail Technologies, as well as the General Counsel and Chief Compliance Officer. I basically keep TTT honest.
Sir, what's your educational background?
I received a degree in International Business from Common University, as well as a joint JD MBA from NYU.
What's your professional experience?
I worked at the law firm of Drinkert and Racken, also known as D&E. I worked there as an associate in the International Corporations Group till 2006. I then joined the Securities and Exchange Commission, or the SEC, and then in 2010, I rejoined D&E and eventually made partner.
Sir, you mentioned the Securities and Exchange Commission. What did your job at the SEC entail?
I prosecuted companies for over 4 years. No issue was too large or too small. Our corporate prosecutions range from some small accounting errors to some of the largest corporate prosecutions.
Sir, you mentioned did you receive any recognition in your field?
Yes, I did. Actually, at the SEC in 2010, I received the Director's Award for my work on the Siemens prosecution. The $800 million payment by Siemens is considered an FCPA landmark.
Sir, you mentioned the FCPA. Could you tell the jury what that is?
Of course. The Foreign Corrupt Practices Act. It's a law that, in simple terms, makes it illegal for any U.S. company to offer a bribe to an overseas official.
Did you render an opinion in today's case?
I did.
Did you rely on sufficient facts and data in rendering that opinion?
Absolutely.
Mr. Inoki, did you render all the opinions that you're going to share with us today to a reasonable degree of professional certainty?
Of course.
Thank you. Your Honor, at this time, the defense offers Mr. Riley Inoki as an expert witness in the fields of international business, corporate investigation, and federal bribery standards.
Any objection?
No objection, Your Honor.
The witness will be recognized as an expert in these 3 areas.
Yes, Your Honor. Mr. Inoki, how did you become involved in today's case?
Silva Morel, a former TTT intern, approached me on August 1st of 2014. He told me that Casey Porcini offered a bribe to an overseas official, Henri Biton. I immediately knew that I needed to conduct an investigation.
Sir, what were the results of that investigation?
Well, after interviewing the relevant witnesses and applying my expertise and knowledge in bribery standards, I reached the conclusion that in all likelihood, Henri Biton actually offered the bribe. Casey Porcini declined it.
Well, did this surprise you, Mr. Inoki?
Not at all. You see, I've worked with bribery standards for years. It's important to realize that in other countries this type of behavior is considered common.
Did TTT violate the Foreign Corrupt Practices Act?
No, they did not.
I want to talk more about Silva Morel. You mentioned him earlier. Was that August 1st interaction the first interaction you had with him?
No, actually I was involved in the hiring process of TTT's summer internship program.
What was your role in that process?
Well, I actually advised management not to hire Mr. Morel.
Why'd you do that?
Well, Mr. Morel was gifted, but he was also unpredictable. He pulled pranks around the office, and I had concerns from the very beginning that they could potentially harm the company.
Sir, you said that you had concerns from the beginning that they could harm the company. Did his pranks ever harm TTT?
That's an understatement. Fortunately, in August, I had to do damage control on another one of Mr. Morel's pranks. However, this one was no shock pen or whoopee cushion. It was rather serious. He had jeopardized company trade secrets.
What exactly is a trade secret?
Well, some companies choose not to patent their designs and have them remain a secret Take Coca-Cola, for example. They didn't patent the recipe for Coke. Instead, it is a trade secret. It's exactly what TTT did with our product, Tiger Mix.
And how did the plaintiff jeopardize those secrets?
Mr. Morrell broke in Ms. Porcini's office and covered it in Post-it notes. However, TTT's trade secrets were lying on Ms. Porcini's desk while Mr. Morrell filmed it.
Mr. Inoki, how many people saw that video?
Mr. Morrell revealed them to 85,000 people.
And what does this mean for the company?
Imagine if an intern at Coca-Cola exposed the secret recipe to nearly 100,000 people. That's what Mr. Morrell almost did at TTT. He almost destroyed it. He almost cost our company millions, if not billions, of dollars.
And what did you conclude from this incident?
He concluded that Mr. Morrell just wasn't ready to be an executive yet. He almost destroyed the company as an intern. Couldn't risk having him out on the executive team and do any further damage.
Thank you, Mr. Inoki. Your Honor, I have nothing further.
The plaintiff may cross-examine.
Yes, Your Honor. May I proceed?
You may.
Mr. Inoki, you don't like Silva Morrell, correct?
Could you elaborate?
You got mad at Silva when coffee got spilled on your new shirt during one of his pranks, correct?
Well, I was upset at first, but it wasn't a really big deal. He paid for my dry cleaning and no harm was done.
However, you've never really gotten over this, have you?
I believe I've gotten over it. It was over 2 years ago.
Regardless, you are still somewhat upset over this incident, aren't you?
I mean, not really. I try to remain professional when conducting investigations.
So you are not even the slightest bit upset over this still, are you?
Not really. It was in 2014.
Now, I'd like to talk about your investigation. When you first started your investigation, you failed to properly preserve documents crucial to the case, correct?
Well, actually, some documents were corrupted, and I asked the SEC if it was necessary to obtain them, and they said no, so I didn't.
Directing you back to my question, when you began your investigation, you didn't preserve these documents, correct?
Unnecessary documents, yes.
Now, along with this, after Silva reported the bribe to you, you informed both Casey Porcini and Henri Bouton, the two involved in the bribe, of your investigation, correct?
Yes, I did.
And in fact, during an interview with Casey, it was after she became aware that Silva reported the bribe to you that she became noticeably angry, correct?
I wouldn't use the word noticeably angry.
However, you noticed that Miss Porcini was upset whenever she discovered that Silva reported the bribe to you, correct?
Your Honor, calls for speculation.
May I respond, Your Honor?
You may.
Seeing as the witness was in this investigation that he performed with Miss Porcini, he would be able to use his rationally based perception to testify as to what it seemed Miss Porcini was upset by this at the time.
May I be heard, Your Honor?
You may.
The witness just testified that he did not actually know if Miss Porcini was angry. He can't testify to whether or not she was actually angry. Miss Porcini took the stand, Your Honor, and no testimony was elicited from her about this. It's not for this witness to make a conclusion on Miss Porcini's mental state.
May I respond, Your Honor?
One more time.
Regardless, in pursuant to the rules of competition, the witness is permitted to use his rationally based perception to describe what he believed happened and if he believed Miss Porcini was upset.
I will permit the question. I believe it's proper cross-examination regarding the investigation, and the witness can answer based upon perception and observation.
Yes, Your Honor.
Thank you.
So again, you would admit that after Miss Porcini became aware that Silva reported the bribe to you, she became upset, correct?
I would not admit that. I wouldn't use the word upset. However, her mood did change.
Now, along with this, after only 1 day of investigating, you left for a 10-day vacation and abandoned your investigation, correct?
I didn't abandon my investigation. I took a momentary leave because I had already paid for an investigation prior to Ms. Morrell telling me about this incident.
So, after failing to preserve documents, informing both parties involved in the bribe, and then a 10-day absence, you returned to find that important documents had been deleted, hadn't they?
No, actually, the documents were not important.
However, documents had been deleted that could have been crucial to the case, correct?
Well, actually, I contacted the SEC and they said that they were not crucial to the case, so I did not recover them.
Regardless, these documents were deleted, correct?
Yes, unnecessary documents.
Now, I'd like to talk about your investigation and the personal successes that resulted from it. You have received money as a direct result of Tigertail succeeding with their product, correct?
I would not use the word direct result.
However, you do profit from Tigertail, correct?
Well, currently I work for them, but during the time of my investigation, I didn't work for TTT.
And along with your current work profits, you also made an agreement with Casey to receive 2/3 of her stock if the product succeeded, correct?
I wouldn't call it an agreement, but Casey was actually a liability and we removed her, and then I bought her shares.
In fact, it was also after your investigation found Casey to be innocent of the bribe that she agreed to sell 2/3 of her stock to you, correct?
Well, no, actually, she was innocent of the bribe, however, not innocent of siphoning off money.
Regardless, after your investigation found Casey to be innocent of the bribe, she agreed to sell 2/3 of her stock to you, correct?
That is correct. I bought some of her shares.
Now, along with this, since the events of the bribe were dismissed, you have been promoted to a leadership position in the company, correct?
Yes, I am currently the vice president.
So, Mr. Inoki, after your investigation found Casey to be innocent of the bribe, you then got 2/3 of her stock and a leadership position. You profited pretty well from this, didn't you?
No, I want to make it clear that Casey Porcini actually was fired from TTT for siphoning off money. She wasn't innocent of everything. However, I am currently a vice president.
Your Honor, I have no further questions.
Any redirect examination?
No redirect, Your Honor.
The witness may step down. Does the defense have any other witnesses?
No, Your Honor. At this time, the defense rests.
Okay. Are we ready for closing arguments?
Yes, Your Honor.
This time, we will recognize the defendant for purposes of making a closing argument.
Yes, Your Honor. May I proceed?
You may.
Actions speak louder than words. When Mr. Morrell took the stand today, he told you a story. He told you that he lost his offer because of what he said, because he blew the whistle. But members of the jury, today the evidence has shown that Mr. Morrell lost his offer not because of what he said, but because of what he did. May it please the court, opposing counsel, and members of the jury. Now, in today's case, the plaintiff bears a burden. They need to prove to you by a preponderance of the evidence, meaning that it's more likely than not that Mr. Morrell engaged in protected activity and faced an adverse employment action because of it. And then the burden shifts to the defendant. We must give a legitimate and non-retaliatory business reason for rescinding the plaintiff's offer. Members of the jury, we haven't just given you one reason today, but we've given you three. We've shown that Mr. Morrell lost his offer because he was unprofessional, dishonest, and irresponsible. Now, first, Mr. Morrell was unprofessional. You heard a lot of testimony today about a trip to Xanadu. And you learned that on the last night of that trip, at the most important business reception in company history, the plaintiff got wasted, almost destroying TTT's trade deal. And you learned that the day they got back, Casey Porcini knew she had to do something. So she immediately took him off all important projects. She reprimanded him 2 weeks before he ever blew the whistle. And second, he was dishonest. And Pat Straw took the stand today and told you that Mr. Morrell would cheat in the office. You learned that this was a concern before he ever blew the whistle. And Ms. Straw told you that executives found out about this cheating during a meeting with all the other interns and executives. And at that meeting, executives learned that their prospective executive was a cheater. And third, he was irresponsible. Today you learned by his own admission that he broke into Casey Porcini's office and filmed confidential trade secrets for 85,000 people to see. You learned that Casey Porcini told Silva to take the video down, but the plaintiff refused. Members of the jury, he was insubordinate. Now, I expect Miss Elma is going to come before you and tell you that everything changed after August 1st, when he reported the bribe. But members of the jury, that's simply not the case. I want you to remember the testimony of the two executives you heard from today. Mr. Morrell was reprimanded for his pranks before he blew the whistle, taken off important projects before he blew the whistle. Members of the jury, that is not retaliation. Members of the jury, TTT knew before he ever blew the whistle that he wasn't ready to be an executive. Now, I expect Attorney Elma is going to come before you and tell you that bad things happen to good people. But members of the jury, the plaintiff has hidden all the bad things that Miss Morrell has done, that he's done to others in the office, that he's done to the company. Members of the jury, Attorney Elma's, at the end of her closing argument, is going to ask you to render a verdict based on the plaintiff's narrative, based on Silva Morrell's words. But we, the defense, ask that you judge him as we all should be judged, by his actions. We ask that you find the defendant not liable, because Silva's actions spoke louder than his words ever could. Thank you.
Plaintiff prepared to give closing argument?
Yes, Your Honor.
You may proceed.
May it please the court? Bad things happen to good people. Silva Morrell was a hard worker, a stellar student on the fast track for management at Tigertail Technologies. Yet this rising star lost everything, simply because he reported a bribe. Good afternoon, Your Honor, members of the jury. The plaintiff and I thank you for your time and attention during today's proceedings. Today, you heard of a greedy company that ripped away the future of a bright young man. However, today, you have the chance to right these wrongs for Silva Morrell. Under Pennsylvania's Whistleblower Protection Act, we, the plaintiff, have to prove to you by a preponderance of the evidence, 1, that Mr. Morrell engaged in a protected activity, 2, that Mr. Morrell suffered an adverse employment action, and 3, that the reason Mr. Morrell's offer of employment was rescinded was due to his engagement in protected activities. If the evidence leans in our favor even slightly, you must find Tigertail Technologies liable. No one can argue that Mr. Morrell engaged in a protected activity. Silva believed to a reasonable degree that he witnessed a bribe. You heard how Casey Porcini asked Henri Baton what it would take to get Tiger Mix labeled as a non-GMO. This was then agreed upon with $5 million, a handshake, and a wink. The plaintiff's expert, Harley Agaricus, told you how he discovered $5 million was missing from Casey Porcini's department. After chasing the money, he found it had been funneled through fake companies into a bank account in San Lorenzo. Shortly after, Henri Baton took a vacation to the island, and conveniently, the bank account was emptied. We did not need to prove that a bribe happened, only that Mr. Morrell had reason to believe that one occurred and thus reported it. We have clearly met that burden. Members of the jury, neither party disputes that Silva Morrell suffered an adverse employment action. What is disputed, however, is the cause. Before the bribe, Madison Blewett, the director of human relations, told you of Silva's impeccable work ethic and high performance reviews. Even the company's CEO praised Silva and offered him a position in the leadership development program. Everything changed for Silva, though, once he reported the bribe. After telling the company's lawyer, Riley Inoki, about the bribe, Tigertail concocted a plan. Cover this up and drag Silva down. Mr. Inoki first warned both Casey Porcini and Henri Baton that an investigation would begin circulating around their bribe. Conveniently, the day after this, Mr. Inoki left for a 10-day vacation, giving Baton and Porcini enough time to cover up their crime. While on his vacation, any documents that were involved with the bribe had disappeared. And what was Mr. Inoki's reward for covering up the bribe? A promotion and 2/3 of Casey Porcini's stock at the company. After reporting the bribe, Silva's performance review started to drop, and he was given more menial tasks at the company. Tigertail claims they have other reasons for rescinding Silva's offer of employment. Firstly, they state that Silva's pranks were an issue. However, from the very beginning, Casey Porcini encouraged Silva's pranks. Tigertail claims that trade secrets may have been exposed when Silva filmed the prank in Casey's office. However, even Ms. Porcini admitted that no trade secrets were exposed. Tigertail claims that Silva's behavior while on the Xanadu trip was embarrassing to the company. However, the day after this trip, a press release was issued that not only had Silva on the front cover, but only contained words of praise for his actions in Xanadu. Now, opposing counsel has stated that actions speak louder than words, and this is 100% correct. Silva's actions of following the law and his incredible work performance speak louder than Tigertail's words of cover-up. Bad things happen to good people. Do not allow Tigertail's cover-up to succeed in destroying the life of Silva Morel. Find Tigertail Technologies liable. Thank you.
Thank you, counsel. Is the jury ready to deliberate? You may proceed to your deliberations at this time. Okay, while everybody's standing, let's give all these participants a nice round of applause. Be seated. This year is my 27th year of involvement in the mock trial competition. I've participated numerous years as a juror. I was an attorney advisor to a team, and for the last 5 years now, I've judged at our county level and the state level. And I can assure you that you young individuals never cease to amaze me. You did a spectacular job today. What I'm especially impressed with is how you grasp the rules of evidence. I was a trial lawyer for 30 years and now a judge for 5 years, and I can tell you, you know the rules of evidence as well, if not better, than many attorneys, and that is very commendable. Being involved in our program, I've also had the opportunity to go on and be involved in the national competition on 2 occasions. And I really enjoyed that as well. And Pennsylvania always represents itself very well at the national level. And I think a lot of that is caused by the fact that we have such an intense and competitive competition at the state level. You prepare each other, you make each other better, you make the other teams better. Our county has had the opportunity to have, I believe, 8 state champions come out of it. And I think we went on to have one of the highest, if not the highest, achievement at the national level. In 2002, Pennsylvania was the runner-up through its team, and a national runner-up, and I was involved in that, and it was very fun. But I've always said that that was driven by what happens right here, what happens in your counties. I look back on my years as a high school junior and senior, and I remember writing a paper and being called to read it or talk about it in front of the class, and I was very afraid. I stumbled around, and these were people that I know, and I was fearful of doing it. You do it in front of people that you don't know, and you do it well. So I can tell you that this competition is important not only for the competition itself, but for your development. The public speaking aspect of this that you derive from it is invaluable. I'll leave you with this thought because I think this is important. In our county competition, I believe we've had, we first, I think, became involved in the late 80s. And we have over 25 people now who are practicing lawyers who have come out of our program. And in 2016, in our county final program, we had the jury comprised of all alumni from our competition. They were all practicing attorneys, many from now partners in major law firms, some assistant district attorneys. It was truly a dedication to what this program produces. So I really wish you luck today. As I told you, there are no losers. There are only winners here. But I really wish you luck, not only today, but in your lives, because if you continue to achieve at the level that you did today, you will all be successes. And you have my heartiest congratulations and respect for what you've done in front of me today. Thank you very, very much. You want your materials back? I have my own copy, so.
Sure, Your Honor.
Okay.
Thank you.
Thank you. Are there any questions or anything any of the participants would like to say at this point? I think you have to fill out your ballots, but if you have any questions or anything you'd like to say, I welcome it. If not, we'll wait. Okay. Thank you.
The PCN family. Our roots run deep. What grew out of a plan to distribute educational programming has grown into the nation's leading statewide public affairs network. Since 1979, PCN has been supported by cable operators across the state. It is because of this generous support that PCN uses no state or federal tax dollars, reaching more than 10 million of our neighbors. Thank your cable operator. We do.
Today's winner, I would take an opportunity first to thank the jury by having them introduce themselves. At that point, the judge will ask the foreperson to rise and read the verdict. The verdict is the winner of the competition. So I just want to make sure that that's very clear to everybody. There was confusion a few years ago. But can we start with the jury just to introduce yourselves?
My name is Lee Russlander. I'm an attorney in Chester County, and my career has been involved with criminal defense.
My name is Catherine Law. I'm a public defender in Cumberland County. Before that, I worked for McNeese, Wallace & Nurick. I've only been an attorney for 2 years, but I did high school mock trial, undergraduate mock trial, and mock trial in law school, and now I coach mock trial. So I have over a decade of mock trial, fake lawyer experience.
My name's Paul Edger. I'm the managing attorney of Mid-Penn Legal Services, which means I serve people that can't afford the rest of them. and I do pretty much everything but criminal work.
Good afternoon, Wesley Payne. I'm a partner at White Williams in Philadelphia, Pennsylvania.
Good afternoon. I'm Peggy Simon. I'm law clerk to Judge Morris here in Gotham County. I'm an adjunct professor at Widener Law School and was in private practice for about 10 years doing family law.
Hi, my name is Bridget Alford. I'm a shareholder with Marshall Dennehy, Warner Pullman and Goggin in its Harrisburg office. We do insurance defense litigation, so I try cases just like this all the time, even in this courtroom, and you both did a great job.
My name is Chester Corse. I'm a practicing attorney in Schuylkill County, Pennsylvania. I'm also the grants chairman for the foundation. They have something to do with the TV people.
My name is Tracy Noggle. I'm a partner in the Blair County firm of Forrest, Openhoff, Kaminsky, and Noggle.
Good afternoon. I'm Lisa Siciliano. I'm the family court administrator in Berks County, and I've assisted in mock trial, including counseling one of our schools for over 10 years.
Thank you, members of the jury. Before we announce the verdict, could we have each side announce the winner of Best Attorney and Best Witness?
Yes, Your Honor. The plaintiff would like to award the Best Advocate Award to Shaylee Desai. And we would like to award the Best Witness Award to Molly Leahy.
Defense?
The defense awards the Best Advocate Award to Emma Bender. And we award the Best Witness Award to Jeffrey Bacchus.
Now, who is the fourth person in the jury? Are you ready to announce the verdict?
We are, Your Honor.
You may.
We find in favor of the defendant.
Jonathan, I gave some comments while you were speaking. Congratulations.
Thank you.
Skeptics said I would never start my own company. A lawyer said I would. I was denied my loan, but a lawyer helped me get one. I couldn't get a lease for my business, but a lawyer saw to it that I did. Skeptics said I would never start my own company. A lawyer helped me prove them wrong.
Alzheimer's disease may have taken away my dad's independence, but a lawyer is protecting his rights. We didn't want Dad to live alone. A lawyer assured us he wouldn't have to. And when Medicare wouldn't cover his medical expenses, a lawyer made sure it did. When Dad's finances were a mess, a lawyer organized them. Alzheimer's disease may have taken away my dad's independence, but a lawyer is protecting his rights.
The Pennsylvania Mock Trial Competition is being brought to you by the Pennsylvania Bar Association, which strives to promote justice, professional excellence, and respect for the law, improve public understanding of the legal system, and provide access to legal services for all citizens. And by the Pennsylvania Bar Foundation, representing the commitment of Pennsylvania lawyers to promote youth justice education and to ensure equal access to the law for Pennsylvania's most vulnerable.